So when you look at the appointment of arbitrators, Section 10 of the Indian Arbitration Act clarifies that the number has to be an odd number. It can't be an even number. Why it cannot be an even number? Because there'll be a tie. There are two arbitrators. One will say yes, the other says no. Then there's another tie, and we will need another arbitration for deciding the verdict. You will have to choose carefully as to what number of arbitrators you want to put in the arbitration clause based on the cost involved. So sometimes what happens is that the contract is 10 crores. You would perhaps want one arbitrator because three arbitrators means the fees of the arbitrator will be multiplied in three. So you always, it's advisable to have only a sole arbitrator in matters where the stakes are low. But there are times when the matters are huge and extremely complicated, involving thousands of crores. Maybe in that cases, you can have some experts on the panel of arbitrator. So you can have three arbitrators. That is useful. Because for one person, it may be difficult to really handle that kind of matter and would need some kind of expertise of other arbitrators. A lot of times, parties, when they do not know what would be the stakes involved, they cap the arbitration clause. They say that, for instance, if disputes are up to 5 crores, there'll be a sole arbitrator. And if it's more than that, then there'll be three arbitrators. And one thing which we have to be very careful about is sometimes what I've seen is an arbitration clause, parties write that the arbitrator shall be an expert in commerce, shall be an expert in maritime. All of that is good, but make sure you don't add so many technicalities that it is hard to meet the relevant arbitrator and you reduce the panel of your pool of arbitrators, prospective arbitrators. So one has to be very careful in that. So skill and the expertise is fine, that's important, but very carefully you have to choose because anything you write is going to eventually reduce the pool of arbitrators. Now the next is ad hoc or institutional arbitrations. Like, ad hoc arbitrations means that for every small little things you have to go to the court for appointment of arbitrator. For all procedural problems, termination of arbitrator, challenge to arbitration, all of these things are decided by the court. You increase the burden of the judiciary and you have to approach the court for every small little procedural lacuna. But whereas in institutional arbitration, the institution takes a call on all of these issues. And institutional, of course, is always preferred. I would always say the reason why India was lacking and did not become a hub of arbitration for a very long time was because there was no culture of institutional arbitrations. And that's why I always say that, go for institutional arbitrations. For instance, if you have to draft an arbitration clause today, you should always put that arbitration will be governed under the aegis of DIAC, which is Delhi International Arbitration Center. So when you have an institution looking after it, the arbitration mechanism as a whole becomes very, very smooth. And in ad hoc, I told you, you never know what is going to happen when. For every small little thing, you have to go to the court. Now, if you're going for an institutional arbitration, especially in an international arbitration, these all institutes have their own clauses, their model arbitration clauses. So if you want SIAC, which is Singapore International Arbitration Center, to be the applicable rule, then you must choose, it's advisable to choose their own model arbitration clause, as that would be perfect. And the only implication of choosing a particular institution as the rule would be that you will be bound by the rules of that institution. So when you are choosing an institution for your arbitration, which is the rules, SIAC rules, ICC rules, you should be well versed and aware with the rules of that institution because you will be bound by it. You cannot tomorrow say that I'm not going to follow it. So that's one thing which I think one must keep in mind. One thing which parties sometimes confuse, they think that if I am choosing ICC as the institution, then please do not confuse. It does not mean you are submitting to the jurisdiction of the courts in Paris. That has nothing to do with the seat. So seat will be deciding that, and institution is merely the rules which will be applicable, and the jurisdiction of the courts of that institution will have no role. It's one thing which I wanted to clarify. Now, in an arbitration agreement, there are three types of law which are governing so one is law governing the main contract. So in any given arbitration clause, like agreement, I said, there are three kinds of the law which are involved. One is the law governing the main contract. One is the law governing the arbitration agreement, which perhaps can be the Arbitration Act 1996 or the amended act. So you always write that the arbitration will be governed by Indian Arbitration Act 1996 as amended thereto or as amended, which means that whatever amendments will happen will be applicable whenever disputes arise. The third is the rules applicable to the arbitration proceedings, which would be the rules which I've just mentioned. Another interesting aspect is the language of the arbitration. Language, why it is important? It is very pertinent because if the language is not specified, in one arbitrations we saw that, especially in international arbitrations, the witness was a French, arbitrator was English, then the other party was Russian, and we were Indians. So if there was no uniform language, then probably the witnesses would be speaking in Russian, the arbitrator would be speaking in English, we would be speaking in Hindi, and the expert would have spoken in French. Therefore, it was pertinent that the translators were used and everything was uniform to make it convenient for all. So that is the reason why I think language is super important to define. Sometimes people think it's just randomly people are writing. Now, multi-tier arbitration clause, like I said, that there are arbitration clauses, and I've seen most of them, where parties write that before you invoke arbitration, you have to first try to settle the dispute by mediation. And parties will try to amicably resolve. And if mediation fails in 30 days, it's not successful, then you can invoke arbitration. So these are prerequisites to be satisfied before invoking arbitration. And that's why these are called multi-tier arbitration clause. So I think this is in practice, this is the new norm. People are doing that. MED-ARB, ARB-MED-ARB. These are some new practices which have now been adopted. I think in Singapore, it's pretty popular. And now in our country also, most of the arbitration clauses that I'm seeing, parties do like to settle it amicably before approaching the arbitration tribunal.